In the 2016 to 2017 adjudicated term, the Iowa Supreme Court issued 182 total opinions. That includes majority decisions, concurrences, and dissents in 116 cases. 98 cases were civil and criminal cases, and 18 were attorney discipline cases. I don't have an exact number of cases that were decided by the Court of Appeals last year, but generally the volume for the Court of Appeals has been about 1,200 cases a year. So the Iowa Supreme Court is issuing fewer opinions than the Court of Appeals, but when they do, some of them, as we're going to talk about, tend to be extremely long. And this, you see that they had 182 opinions, so there's quite a few opinions that aren't unanimous as well. In terms of opinion authorship, Justice Apple wrote the most opinions during the term for 34 opinions. 16 opinions were for the majority, 6 were concurring, and 12 were dissents. Justice Mansfield was close behind with 30 opinions. 16 were majority opinions, 4 were concurrences, and 10 were dissents. Justices Apple, Waterman, and Mansfield, Justices Apple and Waterman had, and Mansfield had the most majority opinions with 16 each, and Justice Zager was close behind with 15. The justices filing the most dissents were Justice Apple, who filed 12, Justice Mansfield with 10, and Justice Wiggins with 9. Later, we'll see that Justice Cady wrote the most concurring opinions with 10. In terms of reversal rates and outcomes, for cases that were on further review from the Court of Appeals, the Court of Appeals was affirmed 24% of the time and reversed 66% of the time, with mixed results in the other 10% of the cases. For district court decisions, the district court outcomes were affirmed 47% of the time and reversed 29% of the time, with mixed outcomes in 12% of the cases. For sources of jurisdiction, the most opinions continue to be direct appeals that get screened to the Supreme Court. Comparing the percentages for the 2016 to 2017 adjudicated term, there were 42% of the appeals were direct appeals compared to the prior term, which was 49%. Quite a few are further decisions on further review from the Court of Appeals as well. You see it's comparable to the prior year's term, with 2016, 2017 being 35%. And the prior term at 34%. In terms of 4-3 decisions, there were 78 of the 116 cases decided were unanimous decisions. That's about 2/3. That leaves about 1/3 of the cases divided, and the 4-3 decisions really are very interesting when you look at the patterns, with there being a clear swing vote in Justice Cady, who went with the majority in 21 cases and was with the dissent in 0, with the others being special concurrences or concurring and dissenting. And the other interesting trend that you can discern from the 4-3 decisions is how the justices certain justices tend to come out on a decision on the same side. So Justices Mansfield, Waterman, and Zager were in the majority in 12 cases, and those were cases where Justice Cady voted with them in the majority. They were in the dissent in 9 cases when Justice Cady was on the other side. And then Justices Apple, Wiggins, and Hecht were in the majority in 10 of the 4-3 cases, and those are the cases where Justice Cady was the 4th vote to make a majority opinion And in those same cases, you saw Justices Mansfield, Waterman, and Sager in the dissent. Looking at the non-unanimous decisions, there was agreement between justices that you can see. For example, Justice Cady and Justice Sager were in agreement in terms of how they decided cases 70% of the time. Justices Apple and Hecht were in agreement 94% of the time, and Justices Mansfield and Waterman were in agreement 94% of the time. There were a few cases where there were recusals. Justice Mansfield participated in every case that was decided in the last term. Justice Apple recused himself in 5 cases. Justice Hecht, Justice Waterman, Justice Sager recused themselves in 2 cases each, and Justice Cady and Justice Wiggins recused themselves in 1 case each. Turning to some of the decisions that the court decided in this term, I'm going to start with a couple of employment-related cases. The first case was decided in June. It was actually one of the last sets of decisions the court issued in the last adjudicative term, Haskenhoff versus Homeland Energy Solutions. This was a very split decision with, well, it's really a 3-1-3 decision with Justice Cady citing with 2 different sides, and it actually takes quite a bit of parsing to read and try to figure out where the court came out. It was, as far as we can tell, it's probably, with all of the different opinions combined, the longest decision the Iowa Supreme Court has ever issued. This was an appeal from what essentially was a $2.4 million judgment in favor of the plaintiff in an employment case under the Iowa Civil Rights Act. The plaintiff asserted hostile work environment, sexual harassment claim, retaliation, and constructive discharge. The jury awarded $1.4 million in damages. That consisted of back pay in the amount of $100,000, past emotional distress in the amount of $300,000, and future emotional distress in the amount of $1 million. Additionally, the district court awarded approximately $850,000 in attorney's fees to the plaintiff's attorney and $250,000 roughly in front pay. This is, I guess from the start, this is a case where the allegations of sexual harassment did not involve physical conduct, did not involve a sexual insult, did not involve groping or anything of that nature. It was inappropriate language in the workplace. And so that's one factor to keep in mind in thinking about this verdict, because it's when someone's awarded $1 million, you would expect there would be something very egregious in terms of physical contact. Not to say that that inappropriate workplace language is not egregious, but there certainly is a distinction that courts make time and time again in hostile work environment cases between physical conduct and verbal actions. So this case didn't involve physical conduct allegations as part of the harassment claim. It was bad language and inappropriate language in the workplace. The plaintiff made a sexual harassment report while she was employed. There was an investigation. She was counseled in the course of that investigation for her own language, and by counseled I mean she was counseled. She, as far as the employer was concerned, she did not experience any tangible disciplinary action that resulted in her losing pay or anything of that nature. She resigned and filed a charge with the Iowa Civil Rights Commission alleging constructive discharge. On appeal, the employer, Homeland Energy Solutions, had multiple arguments, several relating to the district court's jury instructions. They also argued, they had arguments about evidentiary rulings, including an expert witness that the plaintiff used, and they had an argument on appeal about excessive damages. The Supreme Court's ruling focused it primarily on jury instructions. So the first issue was related to whether a plaintiff can assert a direct negligence claim for sexual harassment compared to vicarious liability. The plaintiff sought to assert a direct negligence claim that essentially the employer was negligent by virtue of the fact that that there had been inappropriate language at the workplace and the employer didn't take prompt action to stop it. The plaintiff actually pleaded a direct negligence claim, and that's typically not what plaintiffs assert when they have a harassment claim. They typically seek to impose vicarious liability on the employer for the acts of a supervisor, for example, or coworkers, if the employer, in the case of coworkers, knew or should have known about the harassment, and in the case of a supervisor, it's imputed knowledge to the employer. The court actually did rule in the plaintiff's favor on this issue, finding that the plaintiff can pursue a direct negligence action for harassment. The next issue that the court decided, though, didn't give the plaintiff the relief that probably the plaintiff had contemplated getting, because the court established the elements of proof and the burden of proof for a direct negligence claim, and for in the majority opinion, which was joined was authored by Justice Waterman and Justice Cady concurred. The employee has a burden of proving that the employer knew of the harassment and that the employer failed to take prompt and appropriate remedial action. If the plaintiff had pursued a vicarious liability theory, the employer would need to prove a prompt and appropriate remedial action as an affirmative defense. But because the plaintiff was proceeding under a direct negligence theory, that burden of proof remained on the plaintiff. So the plaintiff certainly recovered the cause of action, the direct negligence cause of action that she wanted, but in doing that, she actually retained the burden of proof on an element that otherwise would have shifted to the defendant. The court also decided an issue about the causation standard for retaliation. This is an issue that has been percolating in Iowa district courts for quite some time, ever since the DeBoom versus Raining Rose decision that the Iowa Supreme Court issued in 2009. In the DeBoom decision, the Iowa Supreme Court decided that but-for causation is not the standard of proof for a discrimination claim, and that the actual causation standard is the plaintiff needs to prove that the protected class was a motivating factor in the employer's decision. Since that decision, there's been considerable it's been a fighting issue in district courts at trial as to whether that same causation standard applies to retaliation claims or not. And there's a distinction under federal law. In 2009, that was the year the DeBoom decision came out. It's also the year that the federal Gross versus FBL Financial Services decision came out from the U.S. Supreme Court. That was a case under the Age Discrimination and Employment Act that found, the court held that the standard of causation for age discrimination under federal law is but-for causation. There's a different standard under federal law under Title VII, and that different standard occurs because Congress drafted the statute to say that there's a motivating factor standard. So Iowa, in contrast to the Title VII law, the Iowa Civil Rights Act actually has what appears to be a but-for standard, because the language, statutory text, is because of discrimination, and so plaintiffs and defendants in employment cases have been fighting over that for quite some time to decide what the proper standard is. In federal court, the U.S. Supreme Court has since then determined that there's a but-for causation standard for retaliation, and so you've seen confusion over jury instructions and what the proper standard is in Iowa state courts for Iowa Civil Rights Act claims for quite some time. The court, with Justice Apple writing for the majority and Justice Katie being the swing vote, determined that the causation standard for retaliation under the Iowa Civil Rights Act is the same as the causation standard in Boom, and that's the protected conduct was a motivating factor in the employer's decision. There was also an issue about a jury instruction regarding an adverse employment action. And that instruction was the majority written by, the decision by Justice Waterman determined that that decision was essentially established adverse actions as a matter of law and was commentary on the evidence. And again, the adverse action had been that the plaintiff received a counseling statement, and so the court found that instruction essentially told the jury to find as a matter of law that it was an adverse action, and that really should have been with the jury's discretion. And then there was also another issue about this proper standard for constructive discharge. In federal courts, at least in the Eighth Circuit, there is a legal analysis that's often seen in employment cases that has typically been used for constructive discharge in terms of the marshalling instruction. And the justices agreed on a couple of points. One, that for a constructive discharge marshalling instruction, the analysis for assessing whether an employee's working conditions were intolerable is an objective standard, meaning what a reasonable person would think, and not a subjective standard. That was one error in the instruction, was that the instruction was somewhat inconsistent and seemingly had both a subjective and objective element in it in different places in the instructions. There's also a principle derived from federal courts that one element of proof is that the conditions won't be considered intolerable unless the employee gives the employer a reasonable chance to resolve the problem. The court determined that that was not a required element of proof, and that the opinion on that was written by Justice Applewood, and Justice Katie proved to be the swing vote on that. There was an issue about expert testimony, and not surprisingly, the court found that in a direct negligent action, that expert testimony on the standard of care for an employer or the standard of practice is admissible. And then maybe one of the more interesting issues in that case, I guess they were all interesting, but one of the issues that the court did not decide was about the excessive verdict issue. And this is an issue that is really percolating in employment cases in the state, and it's one of the reasons that I'm talking about employment cases, because we're seeing verdicts that are extremely high, at least comparatively, in employment cases. Just to go through a few, in July of this year, and there's a Poweshiek County verdict of $4.5 million in an employment discrimination case under the Iowa Civil Rights Act. The jury found in favor of the plaintiff on claims of retaliation, age discrimination, and disability discrimination, and awarded back pay of about $222,000, with the remaining portion of the verdict being $2 million in past emotional distress and about almost $2,300,000 in future emotional distress. That's really disproportionate to the back pay that plaintiff had, and that's a really large amount of damages for an employment case, which employment cases typically have been referred to as involving garden variety emotional distress. I mean, these are numbers that you would expect to see in for individual plaintiff cases in a product liability case or medical malpractice, but certainly employment law where there's an adverse action of someone getting terminated from their job. You don't typically expect to see them when the lost wages are about $225,000. There was the Kirsten Anderson versus State of Iowa verdict in Polk County in July. That case resulted in plaintiff's verdicts on sexual harassment, sex discrimination, and retaliation. And there was no back pay awarded. The plaintiff did receive past emotional distress damages of $1.4 million and future emotional distress damages of $795,000. There's also another case percolating that is pending before the Iowa Supreme Court on an application for further review, Vetter versus State, and that was a case that went to trial in August 2015 in Polk County. That was a disability discrimination case that resulted in a plaintiff's verdict, and in that case, the plaintiff's back pay award from the jury was about $165,000, and the plaintiff received past emotional distress damages of $250,000 and future emotional distress damages of about $185,000. That case has been decided by the Court of Appeals. The Court of Appeals affirmed, and issues on appeal in that case included jury instructions and excessive damages. So there are certainly some issues out there to be resolved by the Iowa Supreme Court about what are appropriate damages in an employment case that involves a single plaintiff termination. And the last guidance we had from that from the Iowa Supreme Court was in 2009 in a case, Jasper versus Nizam, where the jury returned a verdict in a termination case of $100,000 for emotional distress. And in that case, the Iowa Supreme Court said that's too high for a single incident termination case. The court certainly cited some factors that supported a lower damages award, including the fact that the plaintiff didn't work for the employer for long. It didn't have any medical evidence of emotional distress, but it's certainly a principle that continues to govern these cases. And in some instances, it's hard to see the difference between a plaintiff that gets on the stand and testifies, I've had trouble sleeping and I have anxiety because I was terminated, and a plaintiff that says I went to a doctor and got a prescription for anxiety medication and pills to help me sleep. That's medical treatment, but that really has the same result, other than, you know, in some cases someone goes to a doctor and gets medication for it. Another employment case that the court decided this last term is a statutory interpretation case regarding the Iowa Civil Rights Act, Simon Seating and Sod versus Dubuque Human Rights Commission. That was a unanimous decision, although there were a couple of special concurrences filed. And that related to a case that was tried before the Dubuque Human Rights Commission, and the Dubuque Human Rights Commission proceeded under the local ordinance, the Dubuque ordinance, and returned a finding in favor of the plaintiff that he had been subject to race discrimination. It was a small business, the employer was a small business, and the employer appealed, arguing that the plaintiff had not satisfied the numerosity requirement under the local ordinance, which was similar to the Iowa Civil Rights Act, that requires, defines an employer as someone who regularly employs less than 4 individuals, or has an exemption for an employer that regularly employs less than 4 individuals. The court found that the numerosity requirement is not a jurisdictional requirement, it's an element of the plaintiff's burden of proof, and the court departed from the federal law interpretation regarding the numerosity requirement and implied what seems to be a common sense rule that regularly employs looks at the day-to-day operation of the business, and since it was the defendant in that case was a seasonal landscaping business, the appropriate period to look at is when they're actually operating in the season, performing landscaping. And the court affirmed all issues raised in that case. Another case that involved a large damages award was the Thornton versus American Interstate Insurance Company case, which the court decided in May of this last year. Justice Waterman was the author of that opinion, and it was a unanimous decision. That's a case that was a bad faith case. It was a bad faith case relating to a workers' compensation insurer's decision. So the plaintiff was injured in the course of employment, and as a result of the injury was paralyzed below his chest. And there were two primary disputed issues before the Iowa Workers' Compensation Commissioner. One was whether the plaintiff was permanently and totally disabled. The insurer contested that before the Workers' Compensation Commissioner. And second, the employee filed a petition for partial commutation award, which is a lump sum award, and the insurer contested that. When the employee filed the bad faith action in Potawatomi County, the parties filed cross motions for summary judgment, and the court ruled in favor of the plaintiff. The court found bad faith as a matter of law on the denial of the employer's and the insurer's decision to contest that the plaintiff was permanently and totally disabled. And the court also found bad faith as a matter of law and the insurer's resisting the partial commutation award. And those issues were then tried to a jury, with the court instructing the jury that it had determined as a matter of law that those two actions by the insurer were bad faith. And the jury returned a verdict of $284,000 in compensatory damages and $25 million in punitive damages. The court reversed that verdict and sent it back for a new trial. And the reason was the court affirmed on the decision that it was bad faith for the insurer to dispute the plaintiff's assertion that he was permanently and totally disabled. But the court found that it was not bad faith as a matter of law for the insurer to contest the petition for a lump sum award. And because the compensatory damages reflected elements that were related to that bad faith finding, the entire case needed to be retried. Another tort case that the court decided was Stender versus Blessum in June 2016. This was a split decision. This is a case that the plaintiff brought a claim against her former attorney for legal malpractice, assault and battery, and punitive damages. In this case, the plaintiff, the plaintiff was a client of the attorney's, and in the course of that representation, they began an intimate relationship. And some of the legal services that the attorney performed for the plaintiff during that time was he executed a will and sent a letter to her former husband demanding some changes to a divorce decree, also trying to persuade her not to file physical and sexual assault claims against her former husband. While the attorney was representing the plaintiff, they continued to have that relationship. And the relationship culminated in a confrontation at the plaintiff's home. There was a physical conflict. The plaintiff called 911, and the 911 call connected, and part of the confrontation was recorded on a 911 call that reflected that the attorney physically assaulted the plaintiff. The attorney ultimately pled guilty to assault causing bodily injury, and there was a no contact order imposed as part of the sentencing. And in a separate proceeding, the Iowa Supreme Court suspended the attorney's license to practice law for 18 months based on 3 ethical violations: having a sexual relationship with a client, performing a criminal act that adversely reflects on the lawyer's fitness to practice law, and some trust account practices. The plaintiff sued the attorney and had a legal malpractice claim that related to well, the legal malpractice claims were related to the services that the attorney provided when he was representing her and having an intimate relationship with her at the same time. And the plaintiff argued that a violation of the Iowa Rules of Professional Conduct should be establish a per se claim for legal malpractice. And that case did go to trial. The district court granted a directed verdict on 2 of the 4 legal malpractice claims, and 2 of the other 2 legal malpractice claims were submitted to a jury, with the jury finding for the attorney. On the assault and battery claims, the jury found for the plaintiff and awarded just short of $500,000. The court declined to establish a per se that a violation of the Iowa Rules of Professional Conduct is a per se claim for legal malpractice, but acknowledged that a violation of the Iowa Rules of Professional Conduct may be used as evidence of negligence. Related to that, the district court had excluded evidence regarding the attorney disciplinary proceeding relating to the complaint, the Iowa Supreme Court's decision, and the Grievance Commission's findings and conclusions, and the court affirmed that was as not an abuse of discretion, noting that the district court did allow the attorney's statements made in the course of the grievance proceeding to be admitted when relevant. In another tort-related case was Ludman versus Davenport Assumption High School, and that issued in June. That was a unanimous decision, and Justice Wiggins was the author of that case. One initial appellate issue in that case related to the rule regarding proof briefs versus final briefs. So the Iowa Rules of Appellate Procedure established that the parties need to file a proof brief, and then once the appendix is filed, the final brief should be revised to include specific citations to the appendix with no other changes except for typographical errors. And in this case, the one party had filed a motion to strike the other party's final brief because there were apparently extensive changes between the proof brief and the final brief that were made. The court did acknowledge that there were extensive changes. The court declined to take any action on it in that case, noting that it wasn't going to do anything because of the lateness of the party's motion to strike the final brief. What probably happened is the party didn't even notice it until they were getting ready for oral argument and then filed a motion to strike. But the court did say that put counsel, all of us, on notice that in the future, if the court finds on its own or based on a motion to strike that a party has made substantive changes to its final brief from its proof brief, the court will not hesitate to strike the final brief and to require the party to file a new final brief in compliance with the rules. The Ludman case was another case that went to trial before a jury, and the jury returned a $1.2 million verdict in the plaintiff's favor. That case was reversed and sent back for a new trial due to evidentiary and instructional errors. It was in this case, it was a premises liability action for negligence. A high school baseball player had been at an opposing school's baseball field for a game and sustained injuries when a foul ball struck him in the head, and his skull was fractured, and he did have some pretty significant injuries, at least as described in the opinion. There were a number of issues relating to this addressed on appeal. First, the high school had alleged that it should have been allowed to assert the contact sports exception, and the court said the contact sports exception relates to 2 participants in a sport as opposed to a party that is maintaining premises, because this is a premises liability case. So the contact sports exception was not applicable to this case. The court also adopted the restatement of torts third in two respects. One, the restatement of torts third for physical and emotional harm, and 2, the restatement third for for apportionment of liability. So some clear directions that they're going to continue adopting the restatement and the updated restatements as they issue. One issue related to the duty of care for premises liability continues to be a negligence standard for possessors of land to both invitees and licensees, and that goes back to the restatement third of torts. There's also an issue regarding the limited duty rule. The high school argued that the risk of injury was open and obvious to the plaintiff, and the court said that may impact, for example, the contributory negligence of the plaintiff, but it doesn't impact the separate analysis of whether the high school was negligent. And then there was also the high school had requested a proper lookout jury instruction, which the district court did not use, and the court found that it was instructional error to not include that instruction as well. There was also an evidentiary issue relating to what is usual and customary for other baseball fields in terms of designing the dugout areas, and that had been excluded by the district court, and the court found that that should have been admitted. In another tort case, Dinsdale Construction versus Lumber Specialties, the court reaffirmed some of its prior holdings about the narrow scope of a negligent misrepresentation claim. In this case, and this was a decision that Justice Cady authored, and it was a unanimous decision. In this case, the communication of information that formed the basis for the negligent misrepresentation claim was done by an employee of one of the defendant who provided the information solely as a professional courtesy. The plaintiff was a construction company that supplied building materials to a structure, to build a structure by the defendant, which was a lumber supplier. And the plaintiff had requested that an employee of the lumber supplier, who was really essentially a salesperson, go to the site, work site, and inspect the progress. And the employee did that as a courtesy. He apparently had experience in that area in his prior employment, but at this point he'd been doing more sales representative work and hadn't really done that for a while anyway. And he indicated that nothing really jumped out as looking wrong when he briefly visited the work site. And then 9 days later, the structure collapsed. And so the court reiterated, the court said that's not negligent misrepresentation. And in that case, there had been a jury trial, a verdict for the plaintiff, and the court reversed that and remanded it to be dismissed, and found that a duty of care for a conveyor of information arises from the pecuniary interest in providing that information. And when someone is doing that as a professional courtesy, I think there was a fact in the opinion that he maybe handed out some pencils for his employer. That's not enough to establish the pecuniary interest that supports a negligent misrepresentation claim. Another tort claim case that relates to, that was a legal malpractice case, it didn't really get into the substance of the tort claim, but it has a number of interesting issues regarding litigation. So this case is a state of Cox, and it was issued in April of this year. It was a unanimous decision, and Justice Mansfield was the author decision. This was a legal malpractice claim. The parties went to mediation in an attempt to resolve the dispute, and there was a agreement on settlement, except for there was a continual dispute or back and forth about the confidentiality provision of the settlement agreement. And ultimately, the defendant filed a motion to enforce the settlement agreement, and the district court did issue an order enforcing it. And that was one of the issues on appeal, was whether there was actually a settlement reached. And the court held that the parties never mutually assented to the same settlement agreement because they never reached a meeting of the minds on the terms of the confidentiality provision. And so essentially there was never any offer and acceptance to make that enforceable. There's also an issue relating to sealing settlement documents. When the defendant filed a motion to enforce a settlement agreement, the filings were public, and so after filing that motion, the defendant filed a motion to seal all the documents relating to the settlement agreement, and the district court did seal those documents, and the plaintiffs argued on appeal that they should not be sealed. And the court said that it's, Open Records Act applies to the judicial branch. The court can seal court records, and in this instance, there was mediation communications or settlement communications can be sealed under the Iowa Code, and it was consistent with the purpose of mediation that the parties should be able to freely discuss opportunities to resolve the case without the risk that those documents would go public, particularly in this case because the entire dispute that precluded a settlement from being reached was over the language of the confidentiality provision, making it clear that to one party, confidentiality was extremely important. Another case that is a procedural issue is Wellmark versus Iowa District Court for Polk County. And I'm not going to address the class action part of that because there's another speaker doing that. But in this case, which issued in February and was a unanimous decision, the Iowa Supreme Court sustained a petition for writ of certiorari. And what's interesting about this case is there were two prior opinions on the same dispute, the second of which affirmed summary judgment in favor of the defendant and dismissing the Fourth Amendment petition. So the case appeared to be done. On remand, the plaintiffs sought to proceed on new claims, and in particular claims that they had previously stipulated in the district court they were not pursuing. The district court found the stipulation was not binding on the class because it was a class action, and the district court found that that the class was not bound by that stipulation. The Iowa Supreme Court, again, they sustained the writ, meaning they said when we say final judgment, it means final judgment, and this is to protect the basic rule of finality. When there is no remand or procedendo directing the district court to further proceedings, and instead the district court is, the case is over, then that terminates the jurisdiction of the district court to continue the case. And essentially the district court just retains jurisdiction to enforce the judgment. I think I am out of time, so thank you.